I don't just make up answers when I do this stuff. Like when I'm talking to you, I just make stuff up because
it's me.
it just pat you on the head and you go away because I said so. And
You're listening to the Help Me with HIPAA podcast, where HIPAA and humor collide to make learning fun. Your delightful hosts are Donna Grindle and David Sims. Relax, HIPAA help is on the way.
Hi, I'm Ginger McClish from St. Louis, Missouri, medical oncology hematology consultants, and you are listening to the Help Me with HIPAA podcast.
Thank you for that intro. My name is David Sims of HIPAA for MSPs and Security First IT, and joining me is Donna Grindle of Carden. Good morning, Donna.
good morning, David.
How are you? So we had last time we spoke in person was at the boot camp.
I know, right? It was a very, very exciting boot camp. I mean, I love how people are once they leave and the calls that we get and the messages. It's been great. And great feedback on that day that we added. Mm-hmm. As far as what we've heard so far, everybody is a big fan of the extra day. They say it's well worth it to have that time to work with us on their plans. So
yeah, it went well. I was kind of surprised though that when we had our first little game that we played, one of the questions was, how do you feel right now? And they had 4 different options to answer, and for some reason, I need a stiff drink.
Was the number one.
Was the number one answer. And we were like, 3 hours in.
Yeah, that was after my first 2 sessions. So.
It's like, wow.
It's like, welcome to boot camp.
Yeah, it's overwhelming.
So speaking of that, we got one more planned for 2019. And no, we do not know when or where we will do another one in 2019. So if you want to make sure you get one in, then you definitely want to do May. If you are interested on the West Coast, you need to let us know because we're getting a little bit of pressure over here to commit to a new one. But at this point, we're telling everybody we're going to try to come to the West Coast. If you build it, we will come. Mm-hmm. So that will be in the fall, though. So May 15th, 16th, 17th is the next HIPAA boot camp.
Yeah, and we are selling tickets quick for this one, so you better get in.
Yeah, because like 4 or 5 people that were going to come in March moved to May already. So it was like, hey, I've got another option, so let me take it. But early bird pricing ends April 15th, just like your tax return limitations. The
no
early bird
extensions.
limitation. No extensions. You cannot file an extension, although you can call and beg, and we'll see how we do. Whatever story, my dog ate my homework kind of story, better be a good one. But the big news is, and what everybody got excited about, was that we are pre-approved for the Compliance Certification Board of the Healthcare Compliance Association Compliance Certification Board, CEUs. And what is it, like 20-something CEUs? And we give you the certificate and everything. And, as many people have done with other things, file it for whatever CEUs you need or CMEs or whatever it is that you track. And that pre-approval should help you out with all the others. But there's no way we can do all the paperwork it takes to get approved for all of them. So we got approved for the one I need. Anyway, back to the fun of things. Make sure that you let us know. Go to thehipabootcamp.com.
Yep. All the information is there.
Yeah.
Very good.
You can sign up and, click a few buttons and boom, you're signed up for boot camp. And any questions or anything you need, we take care of you from there. And we can hook you up with any of our references who went to boot camp, the new format, and get some input on that. And even our alumni who came liked the new format and the things we talked about. So it was good.
Yeah. I am thinking, though, we may need to put a camera there, not to record, but to take still photos of facial expressions.
I know, right? There's some great ones. What? And those kind of things. So,
yeah, or the the person with their head down in their hands.
Yeah. just to get that little live shot of their head hitting me.
Yeah. Anyway, so today we're going to dive into something that I think you've maybe had some recent dealings with online, but we're going to talk about medical record releases and how it's becoming a really heated topic. And there's several parties involved in this discussion. Of course, we have the patients and their right to the medical records, which comes first. And then you have the providers that are trying to meet their obligations to supply the records. But then there's always the lawyers and, medical record release and information companies. And of course, OCR gets involved. So today we're going to make some sense of that mess.
Well, as best we can anyway. It is truly a mess. And you're right. It's like we added a lengthy discussion about this where we kind of touched on it in previous boot camps. We added, a good bit once we heard that OCR is intending to do an enforcement initiative. We wanted to make sure that we kind of drilled this down for one, and then the sheer number of calls that we're getting about attorneys and issues with attorneys was the number two reason that we wanted to make sure that we covered this. And then, sure enough, after the boot camp, I've had to deal with a couple of clients having issues with this and answering their questions. And then I got involved on people posting what is going on with the lawyers and their high-tech filing for medical record release on the listserv that we do with Georgia MGMA. So a lot of things. And finally, I'm like, I'm talking about this way too much to not talk about it on the podcast. So here we go.
All right. So what are you seeing out there? I know when we talked about it in the boot camp, people were kind of confused about the medical release and the pricing and all that. And I'm sure that's what we're going to get into. But I guess, maybe we need to start with what the medical records release actually defines.
Yeah, we're gonna let's start with what the we're talking about. HE double toothpicks, trying to keep this PG. Anyways, which for those of you who know me, you know how hard I work every freaking time we record. So. What really is part of this is it's a section of the law that was updated as part of high tech, which is why they call it a high tech thing, because they want to throw around that it's new as part of the law, but it's not really about high tech as much as it is about the privacy rule that has always said you need to be able to get to stuff, but they really made it tougher and much more specific after high tech. And so first, let's talk about what you're allowed to do as a covered entity with medical records. There's, the uses and disclosures, and we talk about that all the time. And it starts with 164.502. For those of you who've been to boot camp, you know how to go read the law. So go there. And it says a covered entity or business associate may not use or disclose protected health information except as permitted by this part of the rule. The whole subpart C of part 160 of blah, 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 blah. Anyhow, and list under the permitted uses and disclosures, you are permitted to disclose protected health information to the individual. That's cool. Yeah. They can tell me. And then for TPO, which we always talk about, treatment, payment, healthcare operations, that you're allowed to do. And then there's this really funky incident to a use or disclosure otherwise permitted or required, provided that it has complied with respect to otherwise. Okay, so that one's a big loopy doopy special. Has to do with. That's not one of the things we're going to talk about right now. and then it adds in at 164.502A1 IV4. It says, except for uses and disclosures prohibited here pursuant to and in compliance with a valid authorization. So I can do it with a valid authorization. Okay. And then it goes in to add at 164.502A2 2, covered entities are required to disclose protected health information to the individual when they request it, and they are required to provide it to HHS to investigate the covered entity's compliance. Those are the only required releases and disclosures. Okay. The only time they're required to provide a medical record release is to an individual and to the secretary. Period. Okay. That's important. It is very important. So it is in the list that they may disclose it with an authorization. May. It's very important that we understand may. What does may? Like, Mother, may I? Remember that game?
Yeah.
I wonder if they even play it now.
So I didn't see lawyers listed in the list.
No, not at all.
Okay.
To the individual is required. Others are with a valid authorization.
Okay.
So we talk about that. So what is that release that's required to the individual? That comes under 164.524, access of individuals to protected health information. And the very first part, A1, is right of access. That basically says an individual has a right of access to inspect and obtain a copy of protected health information about the individual.
Mm-hmm.
And then there are 2 exceptions. One is for psychotherapy notes, that there are times where you don't want to tell people what the psychotherapist thinks about you.
You crazy.
I know, right? I'm afraid they're going to shoot me. That's not what you want to say, right? So you don't do that. And you know that they can choose to do, but they are not required to do. And information in reasonable anticipation of a civil, criminal, or administrative action or proceeding. So, maybe if that person's suing you and you've put some notes in the chart about that, you don't have to give them that. So those are the only 2 things that you aren't supposed to give a patient. When they ask for it, you're supposed to give it. And then it says provision of access is under C, item C under 164.524. And it says basically that you've got to do this. It says you must comply with this provision of access requirements. And that is, you must provide the access request. You can't say no to the individual, including inspection or getting a copy or both. You must do this, which is what is reiterating what we've already said, right?
Mm-hmm.
And then item 2 says the covered entity must, it doesn't say may, it says must provide the individual with access to the PHI in the form and format requested by the individual if it is readily producible in such form and format. And if not, then you can kind of say, okay, I can't do that, but I can do these others. You can't just say no. You have to give them options. But if they ask for something that you can easily do, whether you want to do it or not, irrelevant, you've got to do it. It's required. And then the next piece, number 3, under provision of access that you are required to do, it must be done in a timely manner. And that's one of the ones, they say a maximum of 30 days. That means that's just like the breach notification. We want it done as soon as possible, but no later than. That doesn't mean you send it on day 28. It means try to do it as soon as possible. And in that, you can have a discussion with the individual and say, look, I want to get this to you as soon as possible, but, it's a lot of records and it's this and something that you can do to facilitate the timely provision. So you can negotiate that and discuss it with the individual. Okay, so far so good, right?
Mm-hmm.
Makes sense?
So far.
The individual's request for access directs the covered entity, if you're telling the covered entity to transmit the copy of protected health information directly to another person designated by the individual, the covered entity must provide the copy to the person designated by the individual. Okay. The individual's request must be in writing, signed by the individual, and clearly identify the designated person and where to send the copy of protected health information. Okay, so that's a very important piece. You have to send it to the third party if they ask you to. If they do all the right paperwork, you know it's them. It's all identified. You're certain that who they're telling you to send it to is who you're going to send it to. That gets into the whole email thing. You know, if you're going to email it, which you have to do unsecured, even if they, you know, you're trying to tell them, you need to tell them this is not secured. You're kind of stepping outside your HIPAA protections of security if I do this, but I can if this is what you really want. And they say yes, then you have to send it to them. And if you're going to do an email, you better make sure that you have the right email because the number of times that people end up one letter off. So you better have like multiple checks and balances to make sure you mail it to the right person because one letter off. I love softball 429, 33, whatever. And you do 42033, you've got a problem. Hopefully it'll bounce back, but we know how many addresses are out there.
Right.
So you want to make sure you get that right, and you got to give it to them in that manner and do what they ask. Great. I'm going to do what they ask. I am required to do what they ask of me.
Mm-hmm.
Okay. I am only required to give it to them. And I'm required to do what they ask. All right. So now, if they agree, the patient says, yes, this is what I want, then you may, remember the difference, Mother,
Okay.
may I, the covered entity may impose a reasonable cost-based fee provided that the fee includes only the cost of. So it's all cost-based cost. You have to prove what the cost is. And in that cost, you can say the labor for copying the records that were requested either in paper or electronic form. So I'm either going to dump it to a CD or a USB or print it on paper or whatever, and the time that it takes to do that. Well, back in the day when you used to go get the big paper chart, remember that you go in and there was a whole room full of charts there,
Mhm.
and they grab the big paper chart, and somebody would have to stand at the copier copying the pages, because inevitably they would be different. They would have Post-it, crazy stuff. So that took a lot of labor. You would expect.
Right.
But today, I key in the information, access the patient account, click print, and it prints. Not so much labor is
Right.
kind of what we're expecting today. So obviously the labor cost, but cost, they say clearly in the law. Item number 2, supplies for creating the paper copy or the electronic media, if that's what they ask for. So whatever they ask, you can charge what it cost you for those pages or for that CD or USB stick. Makes sense.
Okay.
I can charge you for the postage if you have requested that I mail it. So whatever way you want it mailed, whatever it costs to mail it, I can pass that on to you. And if you've got a huge record and we've discussed it and we're just going to try to do a summary of explanation of it so that the records make sense, then you can charge them for making that summary. But only if the patient requests that summary and you agree to make the summary. You don't have to agree to make the summary. So there's a thing there. So the bottom line is I can charge them for creating the copy, the supplies, sending it, and then if I need to write, if that we've agreed, I'm going to do a summary.
Mhm.
There you go. That's what I can charge them for. If the patient requests a record, that's what I can do. As long as it's all feasible and, it's not like I would like for you to give me a triple encrypted USB drive that I share with you and all. No, you don't have to do that because that is not readily an option in your practice. So it's all within reason because you're not going to open up your own security.
Mhm.
And then just one other thing that got thrown into the mix is the discussion about personal health records. And they are addressed specifically in some other discussions and guidance. And by the way, we'll give you a link to that. But this is like, patient portals is what it was originally talking about. And it also included third-party health record systems. There's a big discussion, Microsoft was doing it, Google's doing it back then. I'm not seeing it as much where you like kept your own records in your own EHR.
Right.
They kind of was like, this is a great idea. And then nobody really wanted to do it.
Mhm.
So they've all pretty much ended it. But the individual may grant the authority to upload information about the individual directly into the individual's personal health record and directly to the individual for the individual to put it into the health record, right?
Right.
So I can give you the login and you can send it to them, or I can give you the information that the health record company says, if I give you this, you can transmit straight to them, or you can give it to me and I can do it. So there you go. That is what the law says. So you want to summarize that in David terms?
And if they ask for it, and then give it to them.
Right. But you're only required to give it to the individual.
Right.
You may give it to others.
Now, what is it about? It says individual's request must be in writing, signed by the defendant, and clearly identify the designated person and where to send the copy. So that's where we're getting into the weeds a little bit, right?
Mm-hmm. That's the part right there. The C3II of 164-524.
Right. So it's saying that the person can designate the records to go to another person.
Mm-hmm.
However, the covered entity must provide the copy to the person designated by the individual.
Right.
So where's the hang up at? I guess is my question. Because it's pretty black and white to me.
Right. So that's where the problem comes in, because for years, and I mean years, there's been this thing where the states would set what the maximum fees were that you could charge for medical record copies. And they would say, you can charge a flat fee plus a per page fee over a certain number. And they would have this whole list, and it was like a menu of what you would end up charging somebody for their medical records. Mm-hmm. And then there's a whole industry they're called ROI, which every time I see it, I think return on investment. And then I have to remember it's release of information for those folks. Mm-hmm. And I mean, there are plenty of companies that are big with lots of money behind them. That is how they make a living, is they take the request, they confirm that it's the right people, and then they release the records accordingly.
Okay.
And so they've been using those fees and then charging, they get paid by the patient and they charge a certain amount for the provider to do the services. But the net of it is, so it's been an expensive outing. And in cases, we're talking thousands of dollars to get these records. And this is why they've really come down on it, because this is all about patient engagement. It's about saying, I can't have patients engaged in their care, which is the actual objective of the new way of doing healthcare in our new world that will save costs, because we will, instead of having people show up, get a checklist and go off, and then come back with a checklist not completed and go off. Mm-hmm. The old way. It's like when you go to the dentist and they say, do you floss? And I was like, when was the last time I was here? That's the last time I flossed, right?
Mm-hmm. Right.
So the whole point is to have the patient engaged in their care. And I can't have them engaged in their care if they can't get their records. And I can't have patient choice with their providers if they want to get a second opinion or, any of those things if the patients can't easily get their records. Said and done. Makes sense, right?
Right.
So that's why they're doing a big push on this, because of the costs and the paperwork and the amount of time it takes to get these things done. Just like when Severino talked about how he couldn't get his own mother's records, right, and they're telling him all these things that are wrong, and he wanted to say, do you know who you're talking to? But, like I said, he didn't say anything. He just, I'm sure, wrote down information to put on a list for auditing. So clearly y'all need to have a little bit of checkup. But back in January 2016, so 3 years ago, not yesterday, not even a year ago, 3 years ago, OCR released some clarifications on this stuff that was in there. And they put some specific details on how you could calculate those fees that we talked about, because everybody was doing their own interpretation, right?
Right. Mm-hmm.
And interpretation, we know how that goes. So they came out and they said, look, there's 3 ways that you can come up with your fees for what you're going to charge to supply medical records to the patient. So these are for your required, that's important, your required information directly to the patient. Okay. So my required information to the patient, I can decide how to charge it one of these 3 ways. And everybody just says, well, I can't afford this safe harbor way, but you have 2 other options. So it's like the easy way I don't want to do, but also don't want to do the more complicated way. So what are you going to do? So way number 1 is you calculate the cost each time, the cost that you can charge. So the labor for doing those steps, the cost of the supplies, the cost of the postage, all those things we went through that you can do the cost on, you track those, and that's exactly what you charge the patient.
Okay. That's very time consuming.
Yeah. I mean, it's the way, IT companies have to bill for time and materials. It's hateful.
Mm-hmm.
I hate, time tickets. They're awful. So then option number 2 is you can calculate what the average would be by tracking those that you're doing. And you say, well, on average, we're going to charge X. And here's how I got that done. Here's how I did my math. And that can then be a standard fee. So you don't have to log the time all the time. So you calculate an actual fee like you and I would do anyway. How long does this take us to do? What is it going to cost us? And then we calculate a fee. They just don't calculate any kind of deal. So there are your first 2 choices. You can do it each time, or you can say, this is what it cost us, and you just don't add profit, which is, normal way most of us have to do business, but that's not the way you generally do it in healthcare. And so that's why everybody's like, well, I'm not doing either one of those.
Right.
So then you get to the third, and the third is a flat fee that is all inclusive, which is important. That means it covers everything. And it's what they call like a safe harbor option. Obviously, the easiest method because you use what fee they give you. The problem is that fee is $6.50.
Which is not a lot.
No. And, the idea, though, is that you're going to, essentially in where we're supposed to be, you're going to be able to click, put in a CD and click, put this patient's record on the CD and put it in the mail. Boom,
Right.
Done. Or click email this and put it in the mail, or click, so you're not going to have to copy it. You're not going to have to print it. You're not going to have to do tons of steps. It really should take like a matter of minutes to create this.
Mm-hmm.
It should. However, you know how long it takes.
Yeah.
So therein lies the problem is, we haven't streamlined and automated all those processes because, there's really not been an incentive now, has there? And we know with no incentive, no automation.
So if a practice decides to charge something other than $650, then somebody that might be a little knowledgeable in this would be, okay, you're saying you're going to charge me $25, but you need to tell me how you came to that, because chances
I've actually
are
done that myself.
Because chances are, if you're using option 1 and 2, it's not going to be around $25. It's going to be something and something cents.
I actually had that happen with a provider who told me I couldn't have my records without paying $25. And I said, oh, no, not unless you can show me how you did that math to get to exactly $25.
It's $24.38.
Right. So I want to know how you calculated that exact $25 to be your average, because clearly you're not charging me exact cost because you don't know what that is yet. And so suddenly my records just showed up. But
they're free.
No,
you got
right?
you paid the go away fee. Just
I know,
here.
but then they're still doing it to other people. I am fully aware that within the last 2 months, they did the same thing. They haven't changed what they're doing, which is, one of the reasons that they're doing this enforcement. They can't say they didn't know. I gave them the exact information like 2 years ago from OCR telling them what to do.
Mm-hmm.
They know it. They were given it. They were told. But here we are 2 years later, and they're still doing it. They have not changed. And that is why we have to do the
podcast.
I know, right? That's why we have to talk about this. But the big issue here is still that even though they know, they don't change anything. Even though I've made it clear, they didn't change anything. And obviously, they didn't question whether I was right, which, that could be a lot of things. Well, we know who she is, and nobody wants to talk to me when I say, can I talk to the administrator?
Mm-hmm.
So, but I know they're still doing it. I know for a fact they're still doing it. And that's why OCR says what we're doing isn't working. Even when you tell the people, and we do the Medscape training where you can get your CMEs, you do all this stuff, people aren't doing it. And that's why we're running into these problems. So that's for the patient again. So they've created the Medscape where you get the CMEs. They're trying to explain it. They're trying to explain why. And they're just saying, look, we've tried it all. Nothing's working,
Mm-hmm.
Carrot isn't working. Stick's coming next.
Well, if you're choosing, I guess the way I'm seeing is if you're choosing option 1 or 2, then you definitely need to keep your documentation about how you came to that number.
Well, you should make a decision anyway and document how you got to your decision.
Right.
So yes, 1 and 2, you got to show your math.
Right. But the other side of the coin is the last option, which is $6.50. That's not the required amount because you have 2 other options there.
Exactly. So when everybody complains that $6.50 isn't enough, it's not a requirement. It's an option.
And so when people come to you and say, I'm not paying more than $6.50 because that's a law, that's wrong.
Yeah. Right. So that's why I didn't say to my provider, I'm only giving you $6.50 and taped it to a letter, which, no, I didn't say that. I said, fine, I just want you to show me what your math is that got you to that number because it must be an average. Because it can't be number 1 or number 3. So it's got to be number 2 because you haven't done the work yet. Can't bill me up front. And it's more than $6.50. So it's got to be an average. I just like to see your math. That's it. That's all I asked for. And everybody else is like, having a fit about the $6.50. Do it the other way. You're free to do it the other way. And the average is the way you deal with that, where you can charge for supplies and those kind of things.
Mm-hmm.
So, that is the thing. It is, they even released additional guidance again in 2016 that says we are not putting a cap on what you can charge. That's not what we're doing. What we're saying is pick one of the 3, and one of the 3 is a flat fee. So do what you want.
Is it safe to assume, probably not, but is it safe to assume that getting the cost for getting these medical records would be similar from practice to practice? Not, in other words, would one place charge $25.38 and the other place charge $125.38? Or should they be closer to the same amount?
In theory, most of them should be close, but again, it's going to depend on what the practice is doing, how long you've seen them, what you're asking for. I mean, you do oncology, for example, you're talking boatloads of records versus, internal med that does primary care, and they're seeing most people once or twice a year.
Okay.
It's going to be very different, and they'll have their base rate, and then they'll have all their different things. So when you get into the specialties, it's a whole lot more data. And like pediatrics, you have a kid that's constantly sick, it's going to be very different than a kid that, somehow just gets up and puts some dirt on it and keeps going. Or, like we were, it's too far to go to the doctor. Go ahead. Go keep playing. Wipe that blood off. But the bottom line there is the method should be the same.
Right.
The method, how they get to those fees, should be the same across the board.
Okay.
And that's where the problem is. There should be a method to the madness.
So are you seeing that people don't understand that there is a method?
Right. That's the bottom line. They hear $6.50 and have a freak. They don't say, the problem is they want it to be easy, like $25. But then when you go look at these, there's a fee schedule. It's $25 for the first X number of pages. And then it's this if it's more than those pages. And then it's $25 for the base plus this for a CD and this for a So, they're doing it anyway.
Right.
The only difference is that base fee. Figure out what the average labor is. Because all the other stuff, and the question is, are you already doing the other stuff at cost, or are you trying to make those a profit center, and why would you be? Those should be done at cost, is what they're saying.
Right. Now, you mentioned something about attorneys earlier, and I know there's some issue with that because we talked about a little bit in boot camp. So how do the attorneys play into this scenario, and where's the misunderstanding when that's involved?
Okay, so for years, obviously, these attorneys that are involved in injury lawsuits and workers' comp things and, all these variety of things that are legal cases that have nothing to do with the patient's treatment. It's something that the patient's going through legally. They need the medical records. Mm-hmm. So they have the patient sign an authorization that then the attorney sends to the doctor's office requesting, basically a proven copy of the medical records. And the reason they want it that way is because it came directly from the doctor. It wasn't, it couldn't have been altered by the patient or anybody else. So you can prove it came directly from the doctor. Well, they've been getting charged all those fees, the same as patients have. And they're saying, well, this new law says I should pay no more than $6.50.
Okay, I see where this is going now.
Right. And, so we already have a lot of problems with attorneys literally trying to bully people into giving up records that they shouldn't. And then you add the fee thing to it. So these attorneys, and I'm not saying all of them are doing it, but I get enough calls and I deal with enough problems that it is a regular issue, which is what prompted the discussion on the listserv. It was, what is going on? Why are all these lawyers now sending me this and giving me pushback? And if you go out there and Google record release fees, then in high tech, you will see where attorneys are telling each other exactly how to handle the pushback and exactly how to make sure they don't pay any more than $6.50. Yes. And, but because, as we already mentioned, people don't get this, then everybody ends up in a loop arguing with each other.
Right.
I know, right? When you're an argument, when neither of you are arguing about the same thing is always very complicated.
Yeah.
So then came the question of, okay, well, is that what I'm supposed to do? And, I have two problems when it comes to the attorneys is trying to bully them into giving up records when they shouldn't, and then trying to bully them into the $6.50. So obviously, I don't just make up answers when I do this stuff. Like when I'm talking to you, I just make stuff up because
it's me.
it just pat you on the head and you go away because I said so. And, But I do a ton of research on these things when it's complicated like this. You know, I ask questions of OCR. I review the published information. I have reviewed what all the lawyers say and what their arguments are and all those kind of things. And then one of the really great pieces that I found, go figure, dates back prior to 2016. When an attorney immediately filed when this new stuff went into place.
Mm-hmm.
This attorney was on top of things. So they filed a complaint the minute a hospital gave them a big fee and said, my fee should be just on cost because here's what the law says. 164, 524, blah, 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 right?
Mm-hmm.
The stuff we just went through. And OCR then evaluated it. So they filed in September 2014, which is technically when HITECH went into effect in a lot of ways, right? Because you had a lot of gives and takes. So somewhere in that time frame, right after the final rule was announced and everything went into effect, the minute that they got a big bill, they filed a complaint with OCR that this was a violation of HIPAA law. So they didn't even wait for the $6.50. So that to me is very telling because, you know, this says this comes before all of these other confusing arguments. This comes right down to what does the law say?
Okay.
Right? So in March 2015, OCR responded to this attorney. And the privacy and security blog at Davis Wright Tremaine, which I got a link to, they published an article on it at that time, and they filed a Freedom of Information request with OCR to get a copy of their response, which they were given, of course, redacted with names and stuff in it. So you can imagine what it's like when you've got lawyers talking to lawyers about legal stuff, how complicated the letter may have been.
Right. Yeah.
It's a thrilling read. It'd be like, wait, what? And I'd make my own little notes and create my own little outline. But here's the net of what they said. If the patient requests their medical records to them, right, whether it's for research or their personal health records or treatment and all that, that falls under a required disclosure. Remember, we said that over and over. It's a required part of the law. And that section of the required part of the law is where the fees apply. And that section of the law with the fees is what their guidance in 2016 applies to. Okay?
Okay.
So a required disclosure. If a patient wants their records to go to a lawyer, they say that's different. That's not a healthcare provider. It's not involved in treatment. That falls under the authorized disclosure, which a covered entity may do, but they are not required to do. And it's drawing a line between, is it for treatment or something else? So I am required to do to the individual directly, and that's when the fees apply. So if the individual asks me for it, I am required to give it to them. And if the individual wants me to send it to a different provider or their designated personal representative, for care and all those kind of things, then I can. But not when it's a lawsuit. That falls under, it's a third party that has nothing to do with your care. It has to do with nothing with healthcare itself. And that falls under an authorized disclosure. So in that case, under authorized disclosures, there's no mention of fees in the law because that's under the first part that we discussed, the may release,
right?
The 164.502. The fees are in 164.524. So what OCR said is that because the lawyer's disclosure falls under 502 and the fees are under 524 and the lawyer doesn't fall under 524, then the state fee structure applies, not the HIPAA fee structure.
Huh. Okay.
See? So if the lawyers don't want to pay, then they can ask the patients to get it for themselves and then the patients can give it to the attorneys. Well, then the attorneys have a little problem of, did the patients alter it? And did they give me everything? So they don't want to do that. But this was from 2015. And, basically it gets down to, as far as the way I look at it, I say, if it's about the patient's treatment, then it falls on, and the patient's requesting it, then it falls under the fee structure. Otherwise, it's not about the patient's treatment. They're requesting their records for some other thing. Then it falls under authorized disclosures, and the fee structure doesn't apply. There you go.
Interesting.
Right. So, does it make sense to you? Can you divide it that way?
Yeah, I can see definitely where both sides are extremely confused.
Right. And again, I got it down to reading that OCR investigation and decision letter from 2015.
Mm-hmm.
And that decision letter may have prompted further discussions in 2016, but nothing in 2016 mentions anything other than required disclosures. And they're saying that's an authorized disclosure, not a required disclosure. Right. So the fees apply to required disclosures. There you go.
This is kind of a classic case we run into, or I do anyway, within the IT community, where they're reading, they Google and read old parts of HIPAA or things around that are no longer valid since guidance has come out, or they're listening to other people tell them absolutely incorrect information, which we had a rant on that a few episodes back.
Yeah. But this case, it's the lawyers interpreting the law, which is kind of their job,
mm-hmm.
and then trying to apply it to their setting. And OCR's job is to make that determination. And without any other thing that's been released about this particular thing, the only thing I found that came from OCR specifically about that question is that Freedom of Information letter that was released. In the blog post, they actually give you a scanned copy of the letter.
Okay.
So until, because I'm big on, what do the HIPAA police say?
Mm-hmm. Yeah.
And it doesn't matter what my opinion of the topic is. What matters is what they say.
Right.
And they get to decide. And many, many times administrative law judges have agreed that they get to decide. And right now, without further guidance, that's the rule.
Okay, but let me make this part clear. If the attorney makes a request for records using the authorization request signed by the patient that they always used, then the normal state fee structure applies. But, and this is a big but if the request from the attorney looks like a nice letter from the patient asking for the records, then it falls under the new requirements and fees. Of course, it has to be signed by the patients as well. But the only difference is the paperwork. So this does not mean that you must charge them $6.50 though. It means that you can charge them the actual cost, the average cost, or a reasonable fee, which OCR believes is $6.50. So don't let the attorneys bully you into this $6.50 fee. We think that you should calculate actual costs for any release that's done based on a letter from the patient. So yes, it is a loophole, and it's that thing that people use to get around conditions they don't like, but unfortunately that's the way it's written, and there's nothing we can do about it until something changes.
And that's what we tell our clients. So we're hoping that division between patient treatment is a required disclosure, anything else is an authorized disclosure. Now, you still have the school records things, but that falls under FERPA, which is a whole different story about providing school immunization records and other things to the school nurse. Not going down that path. We're talking about authorized disclosures for lawsuits that don't involve, because even under the required disclosure, if you have a lawsuit that involves the practice themselves, they don't have to release that. So if they've got information that involves the practice in the records, the practice doesn't have to do that at all. And that is, another telling piece that I don't have to give you this, which is, another piece of the puzzle which we're running into is we actually had a group that called and, I felt sorry for them because she was stressing out. She wants to do, the beauty of it is most of these healthcare people want to do the right thing. And they don't want to make a mistake. They don't want to do anything that could, damage their practice or damage their patients. And then you got these attorneys throwing legal references and all this other crap at them all the time. And so we had a case where the administrator is getting pounded by these lawyers who are demanding these records, and they don't have a written authorization. They say they don't need one because under Georgia law, we've told the other party that we're requesting this, and it's been X number of days, and they haven't said anything, so you have to give it to me. So there you go. And what are you going to do? Right?
Yeah.
So clearly a bit of confusion there, and they're saying you're violating Georgia law, you're doing all this, and blah, 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 and on and on and on, and HIPAA says this, and blah, blah, blah. And here's the thing is the lawyers were wanting the records. It wasn't because they were representing that patient. No, they were representing someone who was suing that patient's parents. So it was a minor child that they were demanding their complete records be turned over.
Oh, no.
Oh, nay, nay, nay. No. And so, she had already, and I read what they had said, and I said, no, don't do it. So she calls the lawyer back and says, look, or it was, the legal aid or whatever, and calls them back and says, we're not going to do it. My HIPAA consultant says don't do it. And they're like, well, who is your HIPAA consultant? And I hadn't told her it was okay to tell. So she didn't do it. And I'm like, darn, I should have told you. But at any rate, they lit into her again. And so she calls me back and I said, you know what? Have you called the parent? And she's like, no, I didn't think I was allowed to because they basically had implied that you didn't get that opportunity because they said, we've already notified them. You don't need to do anything else. And I'm like, oh, no. It's their records. They get to decide. And so I'm still waiting to hear how that one ended up. That was a few weeks ago. But I said, if you call the parent and the parent says it's okay, then you can do it. If you call the parent and the parent says no, then you're not doing it. Because all the laws they're pointing to say you may choose to do this if you think you have reasonable assurances it's authorized. And your answer is, I do not think that, so I will choose not to do it because I may not feel comfortable. So there you have it.
That'd be a fun one to watch.
Yeah. But that's what's going on. And, then the next thing would be, and you're only going to charge me $6.50 for this.
Then you have to find that out.
I know, right? So it's important to note the only required disclosure, the only one required is to the individual and to the secretary of HHS in an investigation of compliance. Those are required disclosures. And even then, there's some areas that may not have to be disclosed because you've got those little psychotherapy notes and legal stuff and all of that. Everything else, you need authorization to do.
It is a fact-specific determination.
Exactly. And, and we've had to say this over and over, well, the state law says I can charge $25. Okay, but as long as the state law is not as stringent as HIPAA, then you follow HIPAA. And if the state law is more stringent than HIPAA, then you follow the state law. So there you go. And you can still calculate, if you can show me how you can get to $25, go for it.
Yeah.
Go for it. It's not a requirement to say $6.50. It's a requirement to show how you're getting to the number. That's it.
Easy peasy.
Yeah. So keep that in mind. And, it'll be interesting to hear what we get responses to this one. But we know that OCR is going to start enforcing it. We know that there's lawsuits from the big release of information companies going on against over the $6.50 thing. This is going to become a bigger and bigger problem. And right now, OCR says our job is to protect the patient's right of access. And we've been directed that we should have more patient engagement in our healthcare system. I can't not do that. So, yeah.
Interesting stuff.
There you go. But the thing is, this part of the law has been out there, since the final rule came out. And that's what that lawyer jumped on. And OCR made a decision, but they didn't publish that to everybody. This was, gotten through a Freedom of Information Act thing.
Mm-hmm.
So, definitely interesting.
All right. Well, one thing's for sure. Some people learned some things on this one today.
Well, I hope so. You need to update your policies and procedures to reflect these requirements.
Yeah.
And, we tell our clients, that if the lawyers are trying to bully them, that if they can convince me, then I'll tell you to do it. Otherwise, no, and here's how you reach her. And I'll be happy to listen to their argument, but I'm also going to have to show them the OCR opinion and say, see this? That's what I'm referring to.
All right. Yeah, good. Make sure you record those calls so we can hear them.
I know, right?
This would be good. All right, folks, that is our episode for today. Hope you enjoyed it. I thought it was extremely enlightening. Make sure you follow us and share us out on your favorite social media site. Rate us on our podcasting app. Yes, we have an app for that. And we need your help. Help spread the word. And as always, send in your questions and ideas. And don't forget that HIPAA is not about compliance. It's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.